So good evening, everybody. I want to welcome you to the March 20th, 2024 joint work session with the Calvert County Board of Commissioners and the Calvert County Planning Commission regarding the Calvert County zoning ordinance update, Articles 1, 2, and 29. Chair would entertain a motion to open the meeting.
Make a motion, we open the meeting to discuss Articles 1, 2, and 29 of the Calvert County zoning ordinance update.
Second.
A motion and a second. Any discussion on that motion? Hearing none. All those in favor say aye.
Aye.
Opposed, motion carries. And I have with me tonight Commissioner Grasso, Commissioner Ireland, and Commissioner Cox. Commissioner Hart could not be with us. Madam Chair?
Thank you. Good evening, everyone. My name is Maria Bueller, and I am joined this evening by Vice Chair Kernan, Commissioner Gadway, Commissioner Freeland, Commissioner Toohey, Commissioner Williams virtually, and Commissioner Dr. Holler. If I could also have a motion to approve this evening's agenda?
So moved.
Second.
I have a motion and a second. All those in favor?
Aye.
Opposed? All right, thank you.
I think we'd like to start with the Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
Good evening, Commissioners.
Good evening.
My name is Will Hager, and I'm a planner with the Department of Planning and Zoning that's been helping out with the zoning ordinance update project. And with me to my left is Rachel O'Shea, zoning planner. And before we get into the focus of tonight's work session, I just want to do a brief introduction. Staff has prepared a draft zoning ordinance to bring the zoning ordinance into compliance with the current comprehensive plan. The draft zoning ordinance was made available to the public in May of 2023. Joint work sessions and public forums have been held monthly to review articles of the draft zoning ordinance and will continue through May of this year. CalvertCountyMD.gov/zoning ordinance update is the website where you can access links to draft articles, the draft zoning map, find out where to send public comments, and other supplemental materials are also available. And the focus of tonight's work session is going to be draft articles 1, 2, and 29, title, purpose, and applicability, definition, and signs. And we'll begin with Article 1, title, purpose, and applicability. Article 1 addresses title and statutory authority, the purpose and application of the zoning ordinance. It includes transition rules such as policies for building permits and variances issued prior to the adoption of the updated zoning ordinance and pending applications. Additional authorities like the authority to create and require the completion of application forms, checklists, rules of procedure and policy statements, and design manuals and design guidelines. An exemption from permit requirements of the ordinance for the maintenance of public utility lines and easement areas. So one thing that was revised in this article was the purpose statement to begin the ordinance in section 1-2, which now states, this ordinance is intended to serve the following purposes. A, to execute the powers authorized by the Calvert County Land Use Article of the Maryland Annotated Code. B, to ensure that the vision set forth in Calvert County's comprehensive plan is implemented by land use regulations consistent with the goals set forth. C, to promote and protect public health, safety, and welfare for current and future generations. D, to preserve and enhance neighborhoods. E, to preserve, protect, and promote the county's employment base. F, to protect the county's natural and cultural resources, and G, to provide oversight and planning to sustain the healthy growth of the county's town centers. And on the next few slides, we'll highlight some provisions that have been added to the applicability section. But before I do so, I just wanted to clarify that these may be new to the ordinance, but they're essentially reflective of policies that exist today. They just haven't yet been codified into the ordinance. So, relation to private agreements, this ordinance does not nullify any private agreement or covenant. However, where this ordinance is more restrictive than a private agreement or covenant, this ordinance controls. The county will not enforce any private agreement or covenant. Relation to town center zoning ordinances, if a town center zoning ordinance does not address a requirement, condition, or issue which is addressed in the zoning ordinance of Calvert County, the zoning ordinance of Calvert County applies. However, with the exception of Article 18 and the provisions of the zoning ordinance of Calvert County are subordinate to any applicable town center zoning ordinance. And the reason for that last statement is that Article 18 includes the use charts and conditions for both districts located outside of town centers as well as districts within town centers. Relation to other laws and regulations, unless otherwise specifically provided, this ordinance controls over less restrictive county or state statutes, ordinances, or regulations, and more restrictive county or state statutes, ordinances, or regulations control over the provisions of this ordinance. When this ordinance refers to another statute, ordinance, or regulation, it refers to the statute, ordinance, or regulation as updated or amended from time to time. Relation to previously recorded plats. Any requirements recorded on plats prior to the adoption of this ordinance supersede any conflicting requirements of this ordinance, with the exception of remaining density. And the reason for that last statement being included there, there have been a number of downzonings related to residential density over the years. So if there was a plat recorded in the 90s or the early 2000s, for instance, that says a parcel has X amount of lots that can still be created through subdivision, that note would be superseded by the density regulations of the zoning ordinance currently in effect. But if there were, say, setbacks recorded on a plat that aren't in alignment with the zoning ordinance currently in effect, then it would be the setbacks recorded on the plat that would apply.
Will, can I interrupt you for a minute? So we got an email, I got an email today from someone who's been watching these meetings and trying to keep up. And the comment that this individual made was, it sounds like a bunch of legal mumbo jumbo, and she really can't understand what we're even talking about. And in those 2 pages you just read, you said ordinance in about every other sentence. Is there a Cliff Note version where you can lay out what those 3 sections really mean in language that the layman can understand?
Well, I can see where you're coming from and where that individual is coming from. And you know, when I started reading through some of these things, I don't have as much experience as some of my other fellow planners, and it can come off that way to me sometimes too. I have a personal preference for some language, just to say the use of the term controls kind of throws me off, or threw me off. I think that's a legalese kind of term. I think it basically means supersede. So there are decisions you could make in terms of the terminology you use when writing these regulations. Sometimes decisions are made, I think, because sometimes the legalese is what you want to go for legal reasons. Well, I think what I was trying to do, I also tried to, in my notes, you know, explain what some of these things mean. It can be difficult to make that all work on a one slide in text. So I guess my answer is I'm trying. But
those paragraphs sort of say that, you know, if there's not a local rule, then the county's rule, unless there's a state rule or a federal rule to supersede, that you're laying out a process there of who,
Right.
whose rules are really in charge, is what basically all that says, I think.
Right, yes, and it can get confusing, which I understand.
It just got that email today, and when you read through all that, I'm thinking, I know exactly what she's talking about, because,
Well, and it's more so in this article than the other articles, because we're really setting up the whole ordinance of
Right.
what it applies to, how it applies,
Right.
what the authority it has.
but we're trying to encourage people to participate, and, you know, it's constructive criticism that they're trying to participate, but they can't follow sometimes. Just like tonight is an example of, you know, somebody sitting in their living room might not have figured out what all that really meant, so, just trying to, sure.
Mark Willis, County Administrator. Will, you understand it from layman's terms, and you've got the big words in there. Can you talk right to the intention of the sentence for the public? I don't think we need to put ordinance in there as often, but just put what you know it means at the layman's level.
But the lawyer might not like that, but.
This lawyer would love it.
So, Will, what does that last paragraph mean? I know you gave us an example, but I forgot what that example was.
So, when you say last
No,
paragraph,
any required, no, the screen you were just on. Any requirements recorded on plats?
right, so, like I was saying, so if there is a setback that's recorded on a plat, you know, the structure was designed around that setback, other development on that property was designed around that setback. So if the zoning ordinance changes the regulations, it's not the updated ordinance setback requirements that would apply to that property. It would be the setback that's already been recorded on that plat, and that development has already been designed around.
In other words, you can't create ex post facto. That's the whole purpose of that.
It's
So,
another
so
legal
that
word.
if you do something and it's legal when you're doing it, you cannot make a law later on that says, now,
That's illegal. Yeah. That's all it is. It's so that the homeowner or the property owner can feel assurance that, hey, if I've done everything they told me to do, they can't punish me later on because they changed the rule real fast.
Well, and especially like for setbacks, for example, if you change it on them, then you could be affecting other things located on the property
Absolutely.
that then might turn that into a non-conforming issue,
Right.
so.
Understood, but the other portion of that last sentence, with the exception of remaining density.
Yeah, so, yeah, like I said earlier, the reason for that being included in that statement is because I believe that there are some instances where remaining density is recorded on the plat, but the density requirements back in the 90s and early 2000s, for instance, were different than they are today and will potentially be in the future. And so we don't want to have properties continue to be subdivided as if they were still in the 1990s, essentially.
So in other words, if a property plat either did or did not have remaining density recorded on the plat, when the new zoning goes into effect, the new zoning for density would apply regardless if it's recorded on the plat or not.
Right, the zoning, the density requirements that are in the draft zoning ordinance and eventually adopted would supersede anything that's recorded on a plat.
Okay, thank you.
Okay, we're going to, and Article 1 is a very brief article, and it is very, it is maybe one of the most legalese articles in the ordinance. But we're going to move on to Article 2, definitions. And so there are terms listed and defined in Section 2-3. Roughly 200 terms have been added and 85 removed. Terms relevant for measurements and calculations are included in Section 2-4. measurements and calculations. And diagrams which illustrate select terminology have been added to this section. Some definitions have been revised to correct flawed wording or to update the definition based on the changes made at the state level, which is relevant for terms pertaining to the critical area, for example. And on the next few slides, we'll just show a few examples of the kind of revisions that were made. So in the current ordinance, the definition of common access drive is an access area measuring between 50 feet and 75 feet wide by between 50 feet and 75 feet long, commonly owned by adjoining lot owners, created to provide access to lots. And in the draft, that's been revised and now defined as follows: an access area created to provide access to lots commonly owned by adjoining lot owners, but may also be owned individually. And this is a definition, an example of a definition with flawed wording that has been revised. And I think the issue staff had with the way this term was defined currently is that it didn't make sense to include a specific 50 to 75 feet by 50 to 75 feet area as part of the definition. And I think the statement on ownership was considered incomplete.
Well, can I ask you a question? When I read this, the original one, and then when I read the draft one, I felt like the 50 and 75 feet were spelled out so people knew exactly what the dimensions were. How are they going to, in the next one, an access area created to provide access to lots, how are they going to know what that area is? Or is that something you all counsel them on when they come for permits and so on and so forth?
Do you want to?
Yeah, normally it would be outlined in whatever documentation they have, whether their property has a plat or whatever their engineer supplying them if they come in for subdivision or whatever. But it doesn't, these areas don't necessarily have a specific defined area. So spelling this out as 50 by 75, that doesn't always exist that way. It could be.
It could be smaller, it could be larger.
Right, so it
Okay.
didn't make sense to have that in there.
Okay, thank you.
Yeah.
And moving on to the definition of phased development. In the current zoning ordinance, phased development is defined as a commercial, non-residential development of a recorded lot or parcel in town center, employment center, light industrial, marine commercial, or rural commercial zoning, in which one specified area of the site is developed before other areas. And in the draft, that's been revised as follows: commercial or residential project that is developed in stages and not at the same time, a plan to show the sequence and phases of the development is approved by the necessary reviewing agencies. And this is another example of a definition with flawed wording that's been revised. I think staff didn't like how the current definition for phased development limited the term strictly to commercial development in specific zoning districts.
Can you give an example so this can be more understandable to people listening? What does this mean? I have a big yellow question mark. What does it mean? Put it in layman's terms.
So this can be something, usually for when an engineer brings a site plan in, if the developer is doing it in sections or phases, the site plan would then be approved as a phased development. So if they're coming in to do multifamily development, but they're only gonna do one building at a time, then it would be broken up into like 3 phases if they're doing 3 different buildings, but they'll be doing them one after another instead of doing all 3 buildings all at once.
And also, some builders, they'll open like section 1 and then they will have advertised that section 2 and section 3 will be coming. Is it that type of
Yes.
thing? Okay, thank you.
And then just last example here, the definition for pier. In the current zoning ordinance, it's defined as any marine structure generally referred to as a pier, dock, or wharf, including pilings and other such facilities used for the wet storage of watercraft. And in the draft, it's been revised as follows: any marine structure generally referred to as a pier, dock, or wharf, walkway, breakwater, including pilings and other such facilities used for the wet storage of watercraft. It does not include any structure on pilings or stilts that was originally constructed beyond the landward boundaries of state or private wetlands. And again, this is a definition that was revised due to a change in the definition at the state level. And so we're bringing our definition in alignment with the same definition that the folks who review projects for critical area and an MDE would use. And on this slide, one of the more substantive revisions of these three articles relates to building height. In the current ordinance, a height of 50 feet plus the roof is permitted for non-residential development in the residential district, the light industrial, and the employment center districts if the property is served by a water supply system which is capable of providing adequate supply for fire protection, is certified by the agency providing fire protection, and is in compliance with Article 38A of the Annotated Code of Maryland. And in the draft, outside town centers, no building or structure shall exceed 40 feet plus the roof, except those buildings or structures listed as exempt in items 2 or 3, which includes things like chimneys, steeples, flagpoles, etc. And before we get into Article 29, signs, in the next few slides, we'll go over a timeline of how we arrived at our current sign regulations. So this goes back, all the way back to 2011. The BOCC directed staff to complete a comprehensive review of the sign regulations using a large stakeholder group to simplify, make more consistent, and to address the following issues: regulation of signs on vehicles, banners, attached to vehicles, parking, and the use of vehicles in parking lots as signs, weak and temporary signs, specifically the placement of signs near competitors' businesses and the lack of enforcement, size of signs, complaints that the permitted size of the signs were too small to read from the road, farm signs for farms not located on a main road, off-premise directional signs, and considering the allowance of electronic signs on and off-premise for individual businesses and or shared by multiple businesses. Meetings were held on a regular basis in 2012 and 2013 to study the issues and to develop a set of proposed changes. In 2015, there was a U.S. Supreme Court decision, Reed versus Town of Gilbert, Arizona, where the court found that communities cannot regulate signs based on the content of the sign, i.e. you should not have to read the sign to determine how to regulate it. Since the county's draft regulations included content-based regulations, the draft regulations needed to be reworked to address the Supreme Court's decision. The county hired a consultant to write new sign regulations to address the U.S. Supreme Court case to be content neutral in 2015, and 3 public meetings were held in 2015 to allow for public input on the draft regulations. And in 2017, a joint public hearing was held adopting the current sign regulations, and options for decision of the joint public hearing included window signs to be allowed with no restriction, exemption of inward-facing signs for stadiums, open-air theaters, parks, and similar use facilities, and electronic message centers where to permit, and the amount of time a message may change. And the updated sign regulations were officially incorporated into the Calvert County zoning ordinance in early 2018. And so Article 29 is where the sign regulations are located in the May 2023 draft zoning ordinance, and includes the following sections: general provisions, prohibited signs, signs permitted without a permit, permitted signs, permitted freestanding sign regulations, building signs, electronic message centers and reader boards, master sign plans, portable signs, and temporary signs. And since there is interest in revisiting electronic message centers, on the next few slides, we're going to review the regulations for EMCs. But before I do that, I just want to make clear that this section in the draft is unchanged from the regulations in the current zoning ordinance. These are all the current regs in regard to EMCs. So EMCs are currently permitted in Prince Frederick Town Center on sites having frontage along Route 24, Deers Beach Road West, or Route 231 west of Route 2. Up to 50% of any permitted freestanding sign, canopy sign, wall sign, or window sign may be composed of a reader board or an EMC. Only one EMC is permitted on any single lot or parcel of record existing as of January 31st, 2018, except parcels that have frontage on 2 or more roadways may have one EMC sign along each roadway. EMCs are prohibited in historic districts, and one EMC is permitted per side of the sign structure, but no more than 2 sides. The images and messages displayed shall be static, and the transition from one static display to another shall be instantaneous without any special effects. EMCs shall be designed and equipped to freeze the device in one position if a malfunction occurs. The display shall also be equipped with a means to immediately discontinue the display if it malfunctions, and the sign owner shall immediately stop the dynamic display when notified by the zoning officer that it is not complying with the standards of this ordinance. The EMC shall come equipped with an automated dimming photocell, which automatically adjusts the display's brightness based on ambient light conditions. And the brightness level cannot exceed 0.3 foot candles over ambient levels. EMCs cannot be located within 200 feet of the property line of a residential structure, which does not apply to residential structures on mixed-use properties. And all EMCs shall be shielded from view of residential structures on adjacent properties through the use of a fence, wall, or vegetative buffer that is installed to shield the view of the sign from a residential structure.
Will, got a question for you. And we only allowing these signs in the Prince Frederick Town Center, is that correct?
EMCs?
Yes.
That's correct.
Along certain roadways.
Correct, along the roadways that we mentioned.
Okay.
And so, back to Article 29 more broadly. The provisions of draft Article 29 are in Section 6-8 of the current zoning ordinance. As we covered in previous slides, Section 6-8 of the current ordinance was updated in 2018. Because the provisions for signs were updated relatively recently, minimal substantive changes have been proposed to Article 29 at this stage in the process. But of course, revisions may be made to this article in the next draft depending on feedback received from the public and the commissioners. But as far as the May 2023 draft goes, the following is really the only substantive revision that was made. And that is adding the language, signs will be removed when the circumstances leading to its erection or installation no longer apply. Is there anything that you wanted to add on why we added it?
No, we get some calls every now and again about people asking about signs that no longer apply to the property, that it's there. And just as far as the purpose, one of the purposes of the Article 29 is to keep the county in decent order and have it be pleasant, and so this is one of those cleanup things that just made sense.
What do we do with the advent of shopping centers up and down Route 4 and businesses with, beer being advertised on sale, mattress flags flapping, and then on the weekend, and it seems to go into the beginning of the week, we have those trashy little signs, you have to have 50 of them, in one spot. I don't know why. I mean, what do we do about that, and what can we do? What's in place that we can perhaps clean that up? Because it's really looking trashy up and down Route 4.
Well, I wasn't necessarily involved in this, but we just put out a press release that those signs that you're
Because
referring
Mary
to
Beth-
are no longer going to be allowed, and that the Department of Public Works will be picking those signs up.
We had talked about that. That's
yes, so-
great.
Mary Beth Cook, Director of Planning and Zoning. For years, there was what we called a handshake agreement with realtors, and it extended to businesses that we weren't going to regulate if they put signs up on Friday night and took them down on Sunday. It went in waves where they would be compliant because they were limited to the number that they could have, and then it would get all out of control again. State Highway would pick them up on occasion. They haven't been doing that so much anymore. So we got together internally as a county, and Public Works is going to start April 1st picking up those signs, not only on the weekend but during the week. And you're going to have to pay to get them back.
Okay, that's good for everybody to hear. Thank you.
Yes, you're welcome.
What roadways?
Pardon me?
Which roadways?
County and state roadways, so public rights of way.
Thank you.
You're welcome.
Thank
And I noticed that they stopped this weekend. They weren't on my corner.
Really?
Yeah.
They stopped ahead of time. Good.
Well, on slide 20, are there measures taken before we just pick the sign up?
I don't think that we discussed any measures of that nature.
We would definitely look into the use of the property and to see what permits are in our system.
At
We'd
least
probably
phone
go by
call-
it.
Phone call or letter?
Yes, we would probably try to contact them, see what's going on,
Okay.
see what's going on the property. If the
Before we
business
just
is no longer in operation, or, whatever the case may be, we would definitely look into it and try to make contact before we would take action.
Okay, thank you.
You talking about all the little yard signs?
Well, I'm talking about 20 now, signs that no longer apply.
Because that'd be quite a task for all those little yard signs that pop
Well,
up.
no,
to-
not the yards.
Okay,
But
just
the
checking.
larger ones, yes.
Yeah, the ones that pop up on Fridays and come down on Sundays.
All right, are we all on the same page?
I think we are.
All right, great.
So the planning and zoning enforcement officer is gonna be the sign enforcement officer as well?
Yes,
Mary Beth.
as far as our sign ordinance goes,
For everything but the weekend signs.
For everything but the weekends?
Yes.
Okay. So out-of-date signs, somebody had an event a month ago and those signs are still up, they're gonna address those and?
Yes,
That type of-
absolutely.
okay.
They'll be sending the letter. Well, the zoning officer will be sending the letter, but they usually go out through the enforcement office.
Okay, thank you.
Quick question just popped in my head. We all know we're talking about the stick signs that, on the weekends, referencing business, professional, pick a services. Just thought, what about yard sale signs? If somebody's having a particular yard sale and they got a little something they post up somewhere.
If they don't put it in the right of way, then it's permitted.
Okay.
Yes.
But
We
if a
do-
yard sale sign's in the right of way, it's probably not gonna be there
That's
throughout
correct.
the day.
Yes,
Okay,
it's
thank
not permitted.
Okay, so in summary, Article 1, provisions added to address the relationship between the Calvert County zoning ordinance and private agreements or covenants, previously recorded plats, the town center zoning ordinances, and other laws and regulations. Article 2, some definitions have been removed and a number of definitions have been added to the draft. Some definitions have been revised and a new section added that focuses on terminology relevant to measurements and calculations. And Article 29, again, because provisions for the signs, regulations were updated relatively recently, minimal substantive changes have been proposed at this stage in the process.
If I remember correctly, that was pretty contentious back when that was done. I believe the room was full and
Oh, yeah.
What isn't? but,
tempers flared. It's not very full tonight, so apparently everybody's satisfied with the sign regulations. It's those signs that don't conform that are the issue today.
And signs within incorporated towns do not apply to our ordinance. They have their own.
Correct.
For clarification. Okay.
So I think at this time, staff requests that the commissioners discuss the draft articles 1, 2, and 29, if there's anything further that you'd like to touch on, and direct staff regarding any recommended considerations or options to include in the draft for public input.
So the only comment I will make is I do recall back in when we had that heated sign discussion, the sheriff came out that night and commented that they were concerned about the stores that have their entire window covered in signs and the safety issue from their regard. If they get a call to respond for an issue, they can't see inside the store. I didn't know if you'd heard anything from the new sheriff or any other concerns like that.
That's a legitimate concern.
We haven't heard anything recently, not to my knowledge.
I mean, it's no different than a building with a wall where they can't see in. I think that his observation was you have a storefront that's completely glass, but they've covered it entirely in signs, and so when they arrive on the scene, it inhibits their ability to see inside.
And
But-
I do remember that was part of the discussion back when the 2018 sign regs were adopted.
Has there
But-
not been any discussion about at least a provision that you have to at least provide some clean, clear use space?
We have not received any complaints regarding that.
Okay. Anything else?
Check into it with the sheriff.
Commissioner Allen said maybe we want to reach out to the sheriff and see if he does have a concern, because
Absolutely.
it certainly was back then. And in today's environment, things are much different than they were back then, so.
Well, I'm not hearing any other comments or questions at this time, so I'll just close by stating that we have an open public comment period for draft Articles 20 and 21 from March 8th to April 5th. We had a public forum on those articles last week. Articles 20 and 21 include forest conservation and natural resources. And the next public forum is scheduled for April 11th, 2024, right here at the HEB. And our next joint work session is scheduled for April 17th. And we'll see you guys then.
Thank you.
Thank you.
Thank you.
Thanks. Thank you. So I need a motion to adjourn?
Commissioner, public
Oh,
comment.
I'm sorry.
It's okay.
I'm sorry.
If there's no other discussion, does this even work?
I've been working every night this week. I need a break.
And it's not over.
I know.
Not so quickly.
If there's no other discussion on the work session, we can move on to public comment. Commissioner? Proceed?
There you go. I was
All
very
right.
intuitive.
Thank you. If I may, the board adopted a resolution in 1989 to maintain the order and decorum of the governmental process. A copy is found to my right. Persons are welcome to address the Board of Commissioners on any matter germane to the business of county government. Those addressing the board shall not be uncivil, rude, vulgar, profane, or otherwise disruptive to the conduct of the board's business. All speakers must identify themselves, and whether speaking as an individual, where you'll be allocated 2 minutes, or as the appointed spokesperson of a group, where you'll be allocated 5 minutes. For those attending virtually, if you wish to speak, please press 9 or use the raise your hand function. The Ethics Commission has asked we remind speakers at public comment that lobbyists include those who seek to influence public policy, and lobbyists must register in advance. Do we have any speakers in person? Please come on up.
I had a lot of trouble with this last time. Okay. My name's Bob Estes, and I'm feeling good, so don't worry about my health. I'm still here. but I am touched by the sympathies I got. I'm representing Friends of Hunting Creek tonight. Dr. Ron said I could, so here we go. Will, could you go to slide 4, please? That might be helpful. Thank you. One more. This has been a long-term stick in my craw, so to speak. That the Part G there, when you look at that, we use things like sustainability, healthy growth, and things like that. I have no idea what that means. I don't know what it means to the people that drafted the ordinance. I don't know what it means to the citizens. I don't know what it means in terms of density. I don't know what it means in terms of how much growth is allowed. I haven't seen any analysis planned that I've heard of. I've not seen any analysis as to what the long-term impact of whatever we choose to be sustainable or healthy would be. And without that, the word's not only meaningless, it's also more like sugarcoating to make everybody feel like something good is happening when in fact we have no idea what we're really talking about there. It's pretty much all I have. We've asked for these analyses in the past. I don't know when it's coming. I hear that it might be coming. Whether it's coming in time to make a difference with the ordinance, who knows? I don't know. But I think we need to have analysis that puts numbers to what, sustainable, what healthy, how much growth, is zero growth what we're looking for? Are we looking for the same percentage we have now, which is still compound interest, just keeps going up? How much can the county afford to grow and still be the county we love? I mean, anybody up here hunt or fish, or do they hike? Do they enjoy not having a lot of excess noise? We do care about the vibe of the county. That's really hard to quantify. But I think we need to get down to real numbers and real facts or real definitions on this. I think we all are owed that. So, thank you.
Thank you.
Thank you.
Are there any other in-person speakers? Mr. Buckmaster, do we have anyone online?
There is one person online. If anyone wishes to speak, please use the raise hand function on Zoom or press *9 on your telephone.
Thank you. With that, we'll close public comment.
Thank you.
Just need a motion.
President, make a motion to adjourn?
Second.
Have motion and a second to adjourn. Any discussion on that motion? Hearing none. All those in favor say aye.
Aye.
Opposed? Thank you. Madam Chair.
Thank you. If I could have a motion to take a brief recess and then we'll return for our regular meeting?
So moved.
Second.
I have a motion and a second. All those in favor?
Aye.
Opposed? Thank you.